I defended a monster and put the victim in jail for contempt. A bit of context. I'm going to do my best to keep this short, but full disclosure, I have not defended anyone accused of murder,
But
sexual offenses, violent crimes, property crimes, etc. Yes, also quite a bit of my caseload is domestic violence defense. I remember nearing the end of law school, I had to sit and think long and hard about what I was doing, and if I really wanted to make criminal defense as part of my practice. I ended up taking the approach often echoed in this thread. Everyone deserves a defense, and if I respect many people throughout history who are willing to work with those whose society shuns, why can't I do the same? As for defense itself, it's a mixed bag. Some of your clients are really nice people that made terrible mistakes. Some people are desperate and trying to get by. Some people are just awful. Some people are slaves to addiction. I end up taking a lot of it home more than I realize. There has been a few times I've broken down in front of my kids just because I was so stressed not so much about a case, but about trying to get someone into a situation where they could be back with their family or get out of a shitty situation. One case always sticks with me as an anecdote when I'm asked about this. I have represented some monsters. Below is one of those cases. I could tell from the report and all of the information that he was guilty, although he would not admit to such. He did not want to plead out, but wanted a trial. That's fine. That's always going to be the client's decision, and unlike some other people who I knew did what they were accused of, he didn't hem or haw about it. Trial comes. All of the bad facts come from other witnesses. The girl getting bodies slammed into the wall, the imprint of her body in the cracked plaster, her teeth that got knocked out on the floor, her hair getting set on fire, the table thrown across the room and broken, the interviews done by various law enforcement officers getting her statement about what happened, objection to the hearsay, subject to corroboration by the victim, of course. The victim takes the stand. She is still in love with her man. She will do nothing to get him in trouble. She says she did all of those things to herself because she was mad. As the defense attorney, I ask nothing on cross-examination. It would be malpractice to try and get her to say what I know to be true. I immediately request a dismissal. We go to judge's chambers. The assistant district attorney knows I can't give her the information she needs. I'm bound by my duty of loyalty to my client. The judge, who's relatively new on the bench and was in civil practice before being appointed, asks a few questions that I know are inappropriate, and I tell him I cannot answer them. I remind him the state cannot prove anything beyond a reasonable doubt because of her testimony. We leave chambers. The case against my client is dismissed. He's kind and cordial and thanks me. Then the judge finds the victim, burned scars on her head and missing teeth and all, in contempt of court, and locks her up for 30 days. That's a slice of my job. At least I can look to the Constitution and say, this is how it is supposed to work. I have also represented family law cases with similar sets of circumstances. I do not do family law work anymore.